Well, good afternoon, everyone. Welcome to the seminar hosted by the Ontario Legal Philosophy Partnership here at Osgoode Law School of York University in Toronto. Just a few words about the OLPP, as it is familiarly known. It's an institutional arrangement between Osgoode Law School, where you are today, and the Departments of Philosophy of McMaster University and York University, whose primary aim is to facilitate academic collaborations between the three partners in the fields of legal philosophy, as well as cognate disciplines. And it was created in 2011, and it builds on the long history of collaboration between the three partners. Now today we have the pleasure, the great honor, I should say, of having with us a very distinguished guest, Professor Susan Huck, who comes to us today from the University of Miami School of Law and Department of Philosophy. Susan Huck, to say a few words about her distinguished biography, was educated at Oxford, from which she holds a BA and a BPhil, and at Cambridge, from which she holds a PhD. She was a fellow of Newhall at Cambridge from 1968 to 1971, and then a lecturer, a reader, and finally a professor of philosophy at the University of Warwick, again in the UK. Since 1990, she has taught at the University of Miami, where she is presently distinguished professor in the humanities, as well as Cooper Senior Scholar in Arts and Sciences, as well as professor of philosophy and professor of law. Now, throughout her career, Professor Huck has held many distinguished visiting professorships and fellowships around the world, specializing in logic, in the philosophy of language, epistemology, and metaphysics. She has written more than 7 books, edited several, and published, obviously, numerous articles in leading professional philosophy journals, as well as scientific publications. She is no less, I would say, than a philosophical giant of her age. Indeed, in 2004, she found herself included in Peter J. King's book, 100 Philosophers, the life and work of the world's greatest thinkers, which includes philosophers from the East as well as the West, from Confucius to the present day. And so she is one of the very few living philosophers to have been so honored. So obviously we're thrilled to have Susan Huck with us today. And today she will speak to us and present a paper entitled Nothing Fancy, Some Simple Truths About Truth in Law. So I would ask to join me in please welcoming Professor Susan Huck to Osgoode. Thank you.
Okay, a giant, eh? I'd better stand up straight. Thank you very much. Thank you for your invitation. I'm delighted to be here. Let me check first. Do I have enough voice for people furthest away from me? Okay, good. If I drop my voice, just do this. All right. Okay, you know who I am. You know where you are. This actually helped me find you. Okay. I'm going to start by talking about truth and truths. Abstract nouns like life, beauty, truth have 2 uses. They refer both to some property or some phenomenon and to particular instances of that property or phenomenon. And in the second use, they take the indefinite article and the plural form. Oops. Wrong way. Here are some examples. This is, of course, the famous first line of Pride and Prejudice. It is a truth universally acknowledged that a single man in possession of a good fortune must be in want of a wife. You remember the plot. A single man in possession of a good fortune has just moved into the village and all the young women are eyeing him. Notice, a truth universally acknowledged. Or second sentence of the American Declaration of Independence. We hold these truths to be self-evident, that all men are created equal. Truths in the plural, that's the second use. Same goes for other languages. I've checked all those that I have any grip on. I chose for my slide one that I can actually pronounce. Las verdades científicas son como el amor. eternas mientras duran. Scientific truths are like love, eternal while they last. Esa es una verdad de perogrullo. This is a truth everyone knows. Okay, so both the plural and the indefinite article. This dual usage encourages a sort of characteristic class of philosophical confusions. One of which is thinking that truth, which usually grows a capital T, refers to some all-important particular truth. You know, the truth shall set you free, and this is some particular truth that's supposed to do this magic trick. And then, when people react against this kind of exaggeration, you get philosophers denying that there's any value in truth. The particular confusion that interests me here, because I think it's the one that's done the most damage on this topic, is mistaking properties of truths for properties of truth. So, for example, there are many truths, but there's only one truth. Some truths are vague, but truth is not a matter of degree. Those of you who know my work on philosophy of logic know that I once devoted a couple of years to arguing against fuzzy logic. I seem to remember saying, fuzzy logic just sacrifices all the virtues that Frege wanted logic for in the first place. And it is, I think, founded on this confusion. Because some truths are vague, therefore truth must be a matter of degree. Some propositions are only partly true. They're only true in part, but truth doesn't decompose into parts. Some propositions are made true by things that people do. They wouldn't be true if we didn't do certain things. Truth, however, is objective. And some truths only make sense relative to some place, some jurisdiction, some time. But truth is not relative. All right, a little bit of etymology. I don't know why, but I'm fascinated by my etymological dictionary. You learn so much. The English word true, I learn, derives from the Old English word, I don't know how to pronounce it, trial. I bet you don't either, so it doesn't matter what I say. This word survives in a very small number of almost obsolete expressions. Plighting your troth for becoming engaged to be married, and betrothed, meaning engaged. Of course, the word true also has non-propositional uses. For example, the frog is not a true reptile. Or out of true, interesting expression, it means askew. And I don't know if you've ever encountered this one. If you need the wheels on your bicycle straightened up, that's called truing the wheels on your bicycle. A bicycle shop will advertise that it will do this for you. All right, well, there are a bazillion theories of truth. I will simply list them, gesture at their characteristic features, and say dogmatically where I'm going with this. First of all, there's a whole family of correspondence theories, including the logical atomist theories that Russell and Wittgenstein promoted at one point in their lives, and the conventionalist version that John Austin developed in the 1960s. The first class carries an enormous metaphysical burden. All this stuff about facts. I mean, are there negative facts, disjunctive facts? What kind of facts are there? And the conventionalist kind, which is actually sort of elegant, only works for indexical sentences. It doesn't work for non-indexical sentences. Then there's a whole family of coherence theories. There's an enormous tangle of pragmatist and neo-pragmatist theories. The classical pragmatist theories, their proponents, Peirce, James, Dewey, all say, we don't deny that truth is correspondence, we just don't think that that's very helpful. To understand the pragmatic meaning of truth, you need more than that. But neo-pragmatist theories, as in the Richard Rorty style, are far more radical than that, and in my opinion, far less plausible than that. I'm tempted to say whenever I mention Richard Rorty now to do this characteristic thing. And then there's Alfred Tarski's semantic theory, enormously influential, impressively rigorous. But I believe, as Tarski himself said, that this theory applies only to well-behaved formal languages. That's to say, only to the languages of logic and mathematics, and not to natural languages like Polish or English or French, and so not useful for our purposes. The theory that I shall be operating with is the theory proposed by Frank Ramsey, who, as you see, didn't live very long. I think the history of 20th century philosophy might have been different had he lived longer, because his was a remarkable mind. I call his theory laconicist, not redundancy, because he doesn't think true is redundant. Why laconicist? Because laconic means terse or short in English, and the word derives from the Greek lakonia, which is the ancient Greek name for Sparta. So it's a Spartan theory. You can pretty much sum it up in one line. A belief is true if it's the belief that P and P. So Jones is either a liar or a fool is true just in case either Jones is a liar or Jones is a fool. I think this is the simplest and most direct of all the efforts that there have been over centuries of work to articulate what I think of as the Aristotelian insight. You know, that famous remark from Aristotle's Metaphysics, to say of what is that it is true, and to say of what is not that it is not true. I think Ramsey's is the best effort so far. Moreover, there's a lot it doesn't say. It says enough for me to draw certain important consequences. First of all, whatever the subject matter of a proposition, whether it's legal, historical, mathematical, scientific, it doesn't matter, what it means to say that it's true is the same. Namely, it's the proposition that P and P, all a bit too abstract perhaps. For example, it's true that Socrates was sentenced to death for corrupting the young, if and only if Socrates was sentenced to death for corrupting the young. It's true that 7 plus 5 is 12, just in case 7 plus 5 is 12. And to get closer to our topic, it's true that DNA is a double helical backbone out macromolecule with like with unlike base pairs, if and only if DNA is a double helical backbone out macromolecule with like with unlike base pairs. It's true that current Florida law imposes the death penalty for murder in special circumstances, if and only if current Florida law does impose the death penalty for murder in special circumstances, which, by the way, it does. To be sure, there are many things this theory doesn't tell us, about some of which Ramsey was well aware. Among other things, it doesn't tell us whether, for example, ethical claims have truth values. It's completely silent on that matter. What it does tell us is that if they do, then it's true that it's morally wrong to torture babies for fun, just in case it is morally wrong to torture babies for fun. I shall have to return to the question of the truth value of moral judgments in due course, but for now, that's all. All right, legal truths versus factual truths. The distinction seems easy at first blush. What could be simpler? There was a stop sign at the intersection at the time of the accident. This DNA from the crime scene matches the DNA from the defendant. These are factual claims. Someone whose conduct brings about an unintended death in the commission of a felony is guilty of murder. That's a legal truth. Okay. Seems easy. Not only does it seem easy, but in a legal system like mine or yours, where there's characteristic division of labor, it's crucial to that structure, because legal questions are the province of the judge and factual questions of the fact finder, that's to say, normally a jury. So the distinction is absolutely crucial to a system like ours. Not quite by the way. It's sometimes said that a trial is a search for truth. Tanguay-Renaud says this with complete confidence in her introduction to a 1996 report called Convicted by Juries, Exonerated by Science, which is a report on the first considerable number of DNA exonerations of people who had already been convicted of some crime. I think this is potentially misleading. I take it that the job of the fact finder, whether it be a jury or in a bench trial a judge, is to determine whether guilt or liability, depending on the nature of the case, has been established to the required degree of proof by the admissible evidence presented, which is a whole different question from what's the truth of the matter. So that I would take it that my duty as a juror, even if I believed that the defendant did it, no matter how firmly, if I also didn't believe that that had been established to the required degree by the prosecution, my job is to vote not guilty. Moreover, while the key issue in some trials is, factual, there's a mistake on this slide, seems to be a natural law. In every PowerPoint slideshow, there is a typo. Right? I sometimes use this in class with my students because there's always one in my PowerPoint slides for students too. And it's actually an educational opportunity because I can say, okay, what's the difference between what I just said and there is a typo in every PowerPoint presentation? Well, it's not the same typo. Okay. Key issue in some trials is factual. Did the defendant do it? Was the substance they found cocaine? In others, the key issue is legal. Was it permissible to allow a lay witness to give her opinion that the stuff they found in this guy's shoes was cocaine? That's actually an example from US versus Paver, which is a key US case on opinion evidence by lay witnesses. More to the present purpose, there are a lot of mixed and borderline cases between the factual and the legal. For example, since Daubert, which is the leading US case on the admissibility of scientific testimony, the line between admissibility and weight has been somewhat blurred and arguably somewhat shifted in the direction of the court rather than the jury, because Daubert imposes on federal judges, and of course in judges in other jurisdictions that adopted Daubert, to make decisions about whether or not proffered scientific testimony is reliable, which one would have thought of before might be a matter of weight. This can create the illusion that judges' rulings can determine what scientific claims are true, which is, in my opinion, just false. They can't do that. They can determine what's legally reliable, but that's a different matter. What the heck? Okay, yes, most important here. The word law, just like truth, has two uses. To refer to the phenomenon, law. To refer to particular instances of the phenomenon, laws. So, for example, law is distinct from morality. Law is essential to civilized society. That's first use. Second use. Since 1986, the US has had laws relating specifically to injuries allegedly caused by vaccines. That's the second use. This is an example of great interest to me because it's the history of the vaccine courts and the vaccine laws is fascinating. And it's also the locus of the idea that if you can show more than doubled risk, that's either necessary or else sufficient for proof by preponderance that the vaccine injured you. A crazy idea, but the history is fascinating. Legal truths, that's to say truths about laws in the second sense, are scientific truths. They're a subclass of social scientific truths. Specifically, they're a subclass. They're a subclass of truths about the norms of some given society. And of course, social scientific truths are often local to a place and a time. I can give you an example that tickles me. I hope it will tickle you too. I only learned last year that in Costa Rica, they don't have street names and numbers. So if you want to send a letter to a friend, you have to address it, Joe Blow, 3 doors down from the Pizza Hut, on the corner where there's a big oak tree. Can you imagine? Okay, so social scientific truths are local to places and times. And though they're real, they're certainly real, they are also socially constructed. There's a whole body of thought about social constructivism involved there, but I won't pull it out at the moment. And what I mean by this is that they're made true by things that people do, or perhaps by things that people believe, and so on. Similarly with legal truths. For example, the Establishment Clause of the First Amendment to the US Constitution was ratified in 1791. This is the clause that says, Congress shall make no law respecting the establishment of religion. Ratified in 1791, it was first applied to the states only in 1947. Until then, it was always taken to apply only to the federal government. Another example. Florida adopted the Fry Rule. Novel scientific testimony is admissible just in case it's sufficiently established to be generally accepted in the field to which it belongs, in 1952. It reaffirmed its commitment to that rule after Daubert changed the federal scenery. Then it came awfully close to Daubert in Ramirez versus State in 2001, and finally, last summer, adopted Daubert. I have to rejig the Florida part of my scientific evidence course next year because it's all different. Moreover, legal truths, I take it, are made true by things that people do. They wouldn't be true if it weren't for things that people do. Well, what people? What things they do? By the writers of constitutions, obviously. By legislatures, by parties to international treaties, by formal advisory bodies, and by pressure groups that influence legislation. I'm thinking, for example, of the sexual predator laws that many states in the US now have, which restrict where someone convicted of sexual assault on children may live after they've completed their sentence. And almost all these laws were passed in the first instance because there was such pressure from parents in the states to have safe areas for their children. Actually, these laws had many unintended consequences. The Florida law, I'm sorry to say, restricts where these people may live so severely that I'm told by a friend at the PD's office that when someone comes out of prison, having served a sentence for such an offence, his probation officer will tell him what bridge to go live under. And I'm quite sure whatever, the intention was good, but it was certainly not to have a colony of sex offenders underneath one of the bridges. And of course, another way that people make legal truths true is by judicial interpretations of statutes and precedents. For example, the long series of rulings spelling out what's meant by establishment of religion. Congress shall make no law respecting the establishment of religion. Right? Every year there's a new wrinkle on what exactly that means. There's an interesting case before the Supreme Court now about prayers before meetings of a local government body. And then let me now talk about the judicial construction of legal truths. You might get the impression I'm obsessed with dictionaries. I'm not really, but I do kind of like them. I think they're really interesting. Judicial construction of legal truths is a very, very complex business. If you look it up in Black's Law Dictionary, you will find dozens of entries. Oh, by the way, I'm using an older edition of Black's Law Dictionary. It's recently been revised by a guy who, I don't know. I thought when I looked at the new one, I don't really like this nearly as much as the old one. It's not as much fun and it's not as easy to apply either. And I was very relieved when a law librarian with whom I've worked closely volunteered the same thought. Her view was the older editions are better. So this is not just my curious philosophical taste. I'm especially tickled by the thing called the Four Corners Rule, which initially I thought must be something to do with that place where Arizona and Nevada and whatever it is meet. No. What it means is the entirety of a document should be taken into account, all four corners, not just the little bit that suits your purpose. But recently it's been statutory construction, and in particular the question of severability that's been in the news. You couldn't escape it last year because the first round of constitutional challenges to the Affordable Health Care Act all focused on the individual mandate, the mandate to buy health insurance. And they all argued that, first of all, this individual mandate is not constitutional, and secondly, it's not severable from the rest of the Act, and therefore the entire Act is unconstitutional. So far, all those challenges have failed. The distinction that Black's Dictionary makes between strict and liberal construction reminds me to say, much as I like logic, I think logic's a good thing. I don't think it has a central role in our understanding of a legal system. That's to say, I'm not in the least convinced by Christopher Columbus Langdell's idea that a legal system is like a set of logical axioms from which a judge can deduce the correct decision. And if a judge reaches, if two judges reach the different decisions, one of them must be wrong. Okay, I think that's false. I'm with Oliver Wendell Holmes. The life of the law has not been logic, it has been experience. I think Langdell really was, as Holmes very unkindly said, the greatest living legal theologian. It was clever, but it was wrong-headed, in my opinion. Okay. Why? Well, because statutes and precedents have to be applied to new situations, and formal logical reasoning won't get you there. That's the problem. And what you will have to look to is legal history, explicit or imputed legislative intent, considerations of equity, considerations of forward-looking policy, etc., etc. And the idea that when judges disagree, someone's got it right and somebody else did the arithmetic wrong, I think is quite wrong-headed. My favorite case to illustrate this thought is Allegheny versus ACLU. I'll tell you about it very quickly. County of Allegheny, which is where Pittsburgh is, had two Christmas displays. On the steps of the courthouse was a nativity scene with a banner reading Gloria in Excelsis Deo. Outside the city-county building, there was an enormous Christmas tree, and an equally enormous menorah and a plaque saying, City of Pittsburgh values diversity, blah, blah, blah. Question, is either, both, or neither constitutional under the Establishment Clause? I'm making this next part up because I've forgotten which court says which, but lower court says neither. The appeals court says both. It goes to the US Supreme Court, which decides by 5-4 in a plurality ruling that the thing in the courthouse is unconstitutional, but the Christmas tree and the menorah are constitutional. And there are 9 different opinions, none of them logically confused, but each of them giving different weight to different considerations. As Edward Levi wrote a long time ago, new situations arise and people's wants change. Categories used in the legal process must be left ambiguous to allow the infusion of new ideas. Almost better put than Holmes had put it, I think. I think, for example, of the way US tort law changed. You can watch it changing as there are new forms of mining, there are new forms of transportation, there are new forms of manufacturing, distribution. The railroad system had an especially large effect because it grew from a few miles to thousands of miles over a few decades. And there were a heck of a lot of crossing accidents. And a whole body of tort law grew up in response to this. Or more recently, you can watch courts adapting to the ruling in Melendez-Diaz from 2009 that if there's testimony of the results of forensic scientific tests that's going to be used by the prosecution in a criminal case, then the person responsible for the report must show up to testify so he can be cross-examined. Well, if you think about it, if that happened every time, especially given there might be, say, a dozen people involved in one DNA test, then the entire forensic science system is going to break down because they're all going to be flying from A to B to testify in court and they won't have time to do their job. So since Melendez-Diaz, courts have been very carefully crafting in what narrow circumstances you really do have to produce the guy, and in what circumstances you can say his report is just business record. Interestingly enough, the best cases on this are in the military courts because they have routine random drug testing, and consequently a lot of court-martials of people who were found to have drugs in their system. Okay. You have to read this one from left to right, not up and down. Although legal truths are in part made by judicial interpretation, nevertheless, once they've been made, they can be discovered. That's what legal research is. Although courts play a role in the construction of legal truths, nevertheless, the law isn't just what some judge says it is. Judges can get it wrong, and sometimes do. I noticed, for example, a court that managed to confuse an and with an or while applying one of the Daubert factors. That's a nice one. Again, judicial interpretations by my light involve something more than and very different from formal logical reasoning. But this doesn't mean that they're arbitrary and capricious. I expect some are, but they're not normally arbitrary and capricious. They're calling on historical, moral, economic, etc. factors, which different judges will understandably weigh differently. All right, almost done. Some people may say, people do sometimes say to me when I've got this far, yeah, okay, you've been talking about truths about legal provisions, but you haven't said anything about the truth of legal provisions. And, you know, sounds to me, they sometimes say, as if you think legal norms are just like rules of etiquette. You know, they're just pure convention. No, they're not pure convention. I don't think that. Nothing I said implied that. But it doesn't follow from the fact that they're not pure convention that they must be judged by how well they conform to some abstract true account of what's just. That's a much larger step, and not a step I'm prepared to take. So, let me talk about legal norms and moral norms for a bit. First of all, they're conceptually distinct. It's morally wrong to be inconsiderate to your assistant, or your husband, or your students, but it's not legally prohibited. It's morally wrong to buy your term paper from an outfit that sells such things for money. There are many such outfits, I believe. But it's not against the law. Okay, it's not even against the law to write those papers and sell them, interestingly enough. Moreover, legal norms and moral norms are different in extension. There have been morally deplorable laws, but they were nevertheless, like it or not, laws. For example, Nazi race law. This is actually a very, very interesting book on Nazi race laws. And Jim Crow laws in the southern United States. They would be just obvious examples. Of course, there are many others. As this reveals, I do think moral claims, or at least some of them, can be true or else false. I don't believe that we can know which are which a priori, just by thinking about it. I don't really have a fully developed moral theory. I have a deep sympathy with some ideas on this matter developed by James and then further developed by Dewey. A kind of moral fallibilism, an empiricist moral fallibilism. Very roughly, the idea is what's morally desirable is what conduces to human flourishing. And what does that is an empirical question, often very hard to determine. I believe this was also Holmes's view, though this is, the interpretation of Holmes on this matter is controversial, but I believe he too was a kind of moral fallibilist. But I'm not sure that the idea of a unique, morally best legal system, or even a linear ordering of legal systems by moral value, makes any sense. I'm not sure it makes any sense in general, and I'm especially not sure it makes sense when you talk about a modern society where the law is interacting with a lot of other social institutions. So, for example, how tort law deals with medical mistakes and such, and how healthcare is organized, paid for, distributed in the same jurisdiction, are not, you can't consider the moral value of the one without taking the other into account. Same with tort law versus regulatory law. Moreover, I think our moral assessments of what really enables human flourishing are quite fallible, and our foresight is limited. And as a result, well-intentioned legal changes sometimes have unintended bad consequences. That was why I told you in some detail about these sexual predator laws, which I think were entirely well-intended, but which have, at least in some instances, had consequences which are really worse than the problem they're trying to fix. This will tell you that I'm comfortable neither with appeals to a hypothetical judicial Hercules. Gosh, Ronnie's looking exactly like Hercules, isn't he? Nor am I comfortable with simple reliance on individual judges' seat-of-the-pants decisions. Posner doesn't look quite so much like Hercules, but he also looks very confident. Neither of these seem right to me. I would rather rely on the combined judgment of a whole bunch of judges, diverse enough to give different weight to different values, because that's probably the way we'll get the best upshot. All right, now someone will say, someone nabbed me at a conference once and said, okay, I know the question you can't answer. You can't tell me why the law has normative force. Well, I think I can. Any law carries a legal obligation on those in its jurisdiction to obey. And if detection and punishment are sufficiently likely, also a prudential reason for this. However, some laws prohibit actions which are morally deplorable, like, I don't know, bumping off your wife. And there is both a legal and a moral obligation together. Moreover, I think this is important, there can be moral reason to comply even with morally indifferent laws. You know, it really doesn't matter which side of the road you drive on, but whichever side you decide, then it's morally good if everybody does it, because there will be a lot more accidents if people disregard it. And more generally, the rule of law is a requirement, a necessary condition for many aspects of human flourishing. In the case of morally bad laws, there's a legal obligation to comply, but no moral obligation. And there may be a moral obligation to try to get them changed, or to break them, or to start a revolution. Now, I can't tell you when or why your moral obligation is not just to try to get the law changed, but to break it or to start a revolution. That's a very hard question. I think if my theory gave you an easy answer to that question, it would actually be a fault of the theory, because there is no easy answer. It's a very hard question. P.S. Those of you who are philosophically educated, I would like to notice how classically pragmatist this is, how much influence on what I've said today James has had, Dewey has had, Holmes has had. Okay. And this is one of my favorite things about Ontario, is those wonderful, fat, black, intelligent-looking squirrels. So, merci, thank you very much.
Okay, so we'll now open the floor for questions. Anyone? Professor Hodgson. There should be microphones going around for recording purposes. Thank you.
Well, thank you for this very interesting talk. I was wondering if you could say a little bit more about your disagreement with Dworkin. I was actually very surprised that he's relegated to a footnote, because he seems to be, I would think he's the gorilla in the cage for this sort of topic. And I also thought maybe there is an interpretation of his Hercules that would be friendly to the pragmatist. Isn't Hercules just the embodiment of the end of inquiry or something like that?
Okay. May I make a confession? I find Dworkin extremely hard to read. There's something about the confidence that, I don't know, it stops me at the gate, and I'm having great trouble making sense of him. With respect to pragmatism, though, I can say this. Dworkin has written, pragmatism is a philosophy for people who cannot think. That seems to me to be pretty clearly a repudiation of what he understands by pragmatism. But I think it's more complicated than it appears, okay, which I think is partly what you were saying. James, a long time ago, wrote a paper called Pragmatism and Its Misunderstanders. One of the wonderful lines in this really very nice paper is, I can't understand why people persist in putting the silliest possible interpretation of my words. But the fact of the matter is, pragmatism has been widely and profoundly misunderstood. And to be fair, James's writing is so imprecise, though so charming, that it kind of invites this sort of misinterpretation. And I suspect that when Dworkin says what he says about pragmatism, he probably has Richard Posner's version in mind. And the connection of Posner's pragmatism to classical pragmatism is actually fairly distant, so that it's not entirely straightforward. You could, if you were feeling very charitable, just think of Hercules as the guy at the end of inquiry in a Persian sense. But that strikes me as hyper-charitable, to be honest. Too much so.
I may follow up. But then, leaving aside Hercules, so there is a question to which Dworkin thinks he has an answer, and I'm not completely sure from what you said what you think the answer is and whether it has to be different.
Okay, what's the question?
From Dworkin. Well, it's whether the law has a definite content in hard cases, and whether that content depends on certain moral facts. Not detached moral facts, but facts about how the law is best interpreted in light of its internal principles and so on. Now, you said at some point that law isn't just what the courts say it is, and they can get it wrong. Now, that could mean something very pedestrian. That could just mean sometimes they blatantly misapply the law, and then that's not philosophically very interesting. But Dworkin is interested in cases where there's reasonable disagreement about what the law says or how it should be applied. But he thinks that often in those cases there is a fact of the matter as to what the law says, and courts can get it wrong because they're not reasoning properly.
Okay. I meant the uninteresting thing.
Okay. Do you have a view about the interesting thing?
Okay, the uninteresting thing, I think it's actually not uninteresting, not really. For example, one of the things that the Daubert ruling does, which you see in the first Daubert factor, is appeal in a confused kind of way to the philosophy of Karl Popper. Okay. I believe the Supreme Court had not the slightest idea what Popper really said, and that if they had, they would not have appealed to his philosophy of science. Popper says that scientific theories can only be shown to be false. They can never be shown to be true or probable or be confirmed or be verified or anything of that positive kind. He never even uses the word reliable without scare quotes. I don't believe in reliability, he says. And yet the Supreme Court drags in Popper to give criteria for the reliability of scientific testimony. Okay. Now, many federal courts since have taken this thing from the Supreme Court and systematically misinterpreted it. They've taken it to mean this testimony must be testable, that's Popperian. If it's been tested and it's passed the test, that means it's reliable. That's completely un-Popperian. Okay. This is in some sense a misinterpretation of Daubert, right? But it's actually for the good. You see what I mean? It's better that they take it this way, because that's a better philosophy of science than the Popperian one they thought they were following. Some courts get it wrong in another very pedestrian way. The first Daubert factor says, can the testimony be and has it been tested? And some courts have taken this as, can it be or has it been tested, which is an entirely different matter. That's just wrong. Okay. But I think in the hard cases, where it's not, there's some misapplication and you can point to what the thing is that they misunderstood. Right? They've got the logic of it wrong, or there were too many unless clauses and they got mixed up and they really needed it put in predicate calculus to straighten it out. Nothing. But the really hard ones, I would say, no, in those cases, they're making it. I mean, they're making the law, this rather than that, depending on what they decide. And there isn't a fact of the matter to be determined. That is my view. Okay. Which is distinctly not Dworkonian, is that the word? And because I don't think that what's going on here is a simple matter of inquiry, I'm not inclined to introduce the Peircean idea of the end of inquiry, because I don't think that what's going on is simply inquiry. You see what I mean? It's something more like something between interpreting something that's there and making it mean something new. Something usually broader than it did before, sometimes narrower.
Dworkin would say that sounds illegitimate. It sounds like judges are giving themselves a power that they shouldn't really have.
I know. That's why I say it's not Dworkin and it's not Posner either. There's room in between. Yeah.
Professor Dimmock, if you want to take the mic.
Thank you very much. I loved the talk. And I'm very sympathetic to your passionate moderism.
Passionate moderation, yeah.
Passionate moderation. I wanted to just hear a little bit more about the issue of morally indifferent laws nonetheless generating a genuine obligation, because one of the things I've been working on lately is this very old, in some cases, dismissed distinction between mala in se and mala prohibita offenses. And so I take it that what you said towards the end of your talk about perhaps having legal and even moral obligations to obey morally indifferent laws, laws whose content is morally indifferent, like driving on the right or the left. Nonetheless, that's an avenue for establishing an obligation to obey what would fall under mala prohibita under that distinction. And I think that your explanation is absolutely right, that one of the values of law is that it establishes certain expectations, that then violating those expectations is itself wrong, and that all of that ultimately traces back to the conditions of human flourishing. I buy the entire story that you're telling there. So I don't know that I have even a really well-formed question, except to what I'm wondering about is, do you think that there's a limit? Do you think that all mala prohibita offenses are then subject to this kind of analysis that grounds an obligation to obey them, or do you think that there's some that that you have to be able to make that connection between the rule and human flourishing in order to establish the obligation? So it can't just be that it was enacted.
Yeah, I understand. It's not a question I've thought about. Maybe I can edge my way towards an answer if I mention something that I read while I was writing this paper, which actually prompted me to write those paragraphs. The paper has been rather a long time in print because it was written for publication in Mexico, and the translation went through 4 versions of corrections, so it's taken a while. When I was first working on it, it was the time of the Arab Spring, the first stirrings, first in Tunisia and then in Egypt. And when this was starting in Egypt, I read something in the newspaper to the effect that property law in Egypt had reached such a state of decay that something like 80% of the people who either lived in Cairo or owned businesses in Cairo had no legal title to the property in which they lived or out of which they conducted their business. And I looked at that and I thought, good God. It had never really hit me in the gut quite how much it matters that there be a system where you do know that. Right? And where you can be confident that they can't kick you out of your house because you don't own it, or make your business impossible to run because you can't show a piece of paper. You've just been there for the last 100 years. And that was the thought that prompted those paragraphs. Now, in that case, the connection's clear. In the case of which side of the road you drive on, the connection's clear. Once we get to odd little laws, if you pardon the expression, like how big a tax break do you get in Florida if you install a new and a more efficient air conditioning system? Right. Now, there, making the connection is going to be pretty hard, right? Especially if it's a question of whether you get 10% or 11% or 10.5% or something. And there I'm no longer so confident, right? But I think as I'm talking, the sense I'm getting, please don't quote me, but this is just at first blush, it looks to me as if there might be a continuum, right? Of some laws which are in themselves morally indifferent, but which are really, really important to having the sort of society in which people can flourish, right? They're just sort of background stuff. And others much closer to, it really doesn't matter, right? And I think the best I can say is my argument is stronger the nearer you are to that end, and loses force the further you get towards the absolutely piddling little thing.
Right. So one of the reasons I'm interested in this question is because I'm developing a theory of criminalization. And so, you might have an argument for saying that at some point in this continuum, when you get to a certain point in the trifling side, that at the very least we shouldn't use the heavy hand of criminal law with all that entails to deal with things. And so
as opposed to other forms of nudging. Yes.
Or
yes.
tax or.
Yes. Well, I think one of the issues that this line of thought brings up is, if you're thinking in this sort of gradational and pluralistic way that I am, not in a Langdellian theological way, then not all laws have the same standing with respect to these kinds of argument. And there may be cases where I'd want to say something about sledgehammers and nuts, right? And you may have noticed there is just a line or two in the paper which is completely undeveloped. But part of what I'm thinking is that there are some areas of life where one of the things that conduces to human flourishing is the law not getting involved. And that this is why some provisions of Islamic law seem very undesirable, at least to me. Right, but that's a question sort of in the genre of the one that's interesting you, but it's completely undeveloped. I haven't thought about it any more than the one sentence that you find here. Okay.
We have a question over here. If you can pass the microphone, please.
Thank you. Your paper begins with a Spartan conception of truth from Ramsey, but you seem to end with an Athenian conception of truth when it applies to the law. Non-Spartan, because it's not clear that when it comes to legal truths, it's either just true or false, the way it is in the Ramsey picture that you drew.
Not just true or false, but
somewhere in between, not decided, or it's a three-valued system you're adopting.
Okay. All right. Athenian, that's nice. I didn't get it at first. I'm sorry, I was slow. Yes. Ramsey's theory, as I presented it, is completely Spartan. Ramsey himself knows that you need more than that one line. This is the first thing to say. Because that one line explains to you what truth is. In the case where you begin with, it's true that P, for some P, right? You find out what that means by knocking off it's true that, basically. But this technique will not work if you're talking about, say, the proposition that some things Aristotle said were true. You cannot explain what that means by simply knocking off were true, because then you get some things Aristotle said. It's not even a sentence, so that won't do. And Ramsey was very well aware that in order to develop this theory to accommodate that kind of case, you would need what he called propositional quantifiers. That would turn out as, for some p, Aristotle said that p, and p. Okay. Now, that in itself involves some difficulties. Every theory starts out with a simple idea and ends up getting more and more complicated. Right. That involves some difficulties because now you need an account of those propositional quantifiers for all p, for some p. And moreover, you need an account that doesn't rely on the concept of truth, because if it does, you're just going around in a circle and you haven't got anywhere. That's a challenge. I'm simply accepting, it's a challenge, but it looks to me not insoluble, whereas some of the difficulties with some of the other theories I think are insoluble. Now, Ramsey didn't do this, but I have done this in another context, not here, but perhaps it should have been here, given that I prompted your question. You can make sense along Laconicist lines of, for example, talk of approximate truth in terms of P is approximately true, just in case approximately P is true. That is to say, just in case approximately P. And that style is the style in which I would adapt the Spartan view to the Athenian problem that you brought up. Okay. What I'm telling you now derives from a paper called The Whole Truth and Nothing But the Truth, which is about partial truth. Okay.
I know the paper. I was wondering if I can raise the same issue in a slightly different way. Your paper is reminiscent of Plato's Socrates, who asks the difference between courage itself and individual acts of courage in the Laches, friendship versus friends in the Lysis, and so on. You talk about truths and individual truths. But when Plato himself deals with this question in the Theaetetus, he distinguishes between real and apparent truths. And apart from one reference, you don't talk at all about reality and appearance. And I was wondering if there's a reason why you avoid those words, but put all the emphasis on the analysis of truth, which, by the way, is quite common in philosophy these days.
All right. The answer is I can only get so much into one paper. This paper is a bit like my closets at home, where you basically have to close the door already. But 3 days ago, I gave another talk with the title, The World According to Innocent Realism. Innocent realism is my metaphysical theory. It presents a picture of what I describe as a pluralistic universe. That's to say, there is one real world, which is enormously varied and complicated and full, but is nevertheless, in an important sense, not a reductionist sense, unified. Now, I believe, although showing this would take a third paper which I have not yet written, that this sort of conception of truth and that conception of reality fit together, hand in glove. This will be, if I write this third paper, it's beginning to sound like the third man, actually, but if I write this third paper, it will be a controversial one, because there have been people recently, I understand, who have thought that we need, as it were, a pluralistic theory of truth, because the world is so complex. And I believe that's a complete mistake, that this kind of simple theory of truth is actually the best way of handling truths about a very complex world. But that will take argument and it will be controversial, I'm sure.
Thank you.
I already gave away that paper to somebody in the audience there, so I can't give it to you, I'm sorry.
Questions? Yes.
I find it interesting that you dislike fuzzy logic, but seem to be comfortable with approximate truth.
Mm-hmm.
As far as I know, every formal account of approximate truth has failed. And now intuitive accounts, such as Psilos and Alexander Bird's accounts of approximate truth are more in fashion. So I was wondering, how do you make sense of approximate truth?
I think I just answered that. I'll tell you about fuzzy logic. Okay, people don't always realize what Zadi says it is. Okay, all right. I don't know how many people in the room even have heard of this thing. Fuzzy logic is an enterprise developed by an electrical engineer called Lotfi Zadi. And the initial impetus, I believe, was to do with certain engineering problems. For example, how to build a controller for an air conditioner, or a washing machine, or a dishwasher, or the braking system on a subway, right, which is sensitive in degrees and not just either on or off. Okay. So far as I can tell, fuzzy engineering works fine. And the fuzzy set theory on which it calls is, though not in my opinion terribly interesting mathematically, perfectly viable. There's nothing wrong with it. Okay. However, Zadi got ambitious and claimed that what was involved in this fuzzy engineering enterprise was a new logic. A logic in which there are no syntactical rules, truth is approximate, inference is approximate, all of it, everything is approximate, and none of it is syntactic. That was why I said it sacrifices everything that Frege wanted logic for. Moreover, when it comes to the crunch, in my opinion, it involves imposing a completely artificial precision. Because if you look at Zadi's definition of truth, I can't reproduce it exactly. But truth, he says, is a fuzzy set, such that degree of truth so-and-so belongs to it to degree n, and the degree of truth such and such belongs to it in degree m, and etc., etc. This is perfectly precise and absolute nonsense. Right? You know, it's precise, but it's meaningless. I suspect he was in part seduced by some misconceptions about English. He thinks, you know, he notices that we say things are partly true, which is correct, so we do. He also notices that we say that sometimes that's very true. And he thinks that means true in a high degree. Well, no, sorry, it doesn't. It means true and very important. Right? And he thinks we say, that's rather true. Well, except when I'm quoting Zadi, I've never said this in my life. This isn't even English. So I think fuzzy engineering, fuzzy set theory, fine. Fuzzy logic was a badly confused meta-rationale, which it didn't need, right? But which Zadi has devoted much of his life to defending, sadly. Let me tell you, may I tell you an anecdote? It's a really good one. It's really, really good. I once attended a conference on fuzzy logic at Queen Mary College in London. I should say London, England, while I'm here, shouldn't I? Where Abe Mandami was the organizer. He is a very capable engineer who has done a lot of the applications of fuzzy logic. And he told this wonderful story about how he'd applied for a grant to do his work. And instead of just saying, you know, I want to build a controller for cement kilns that will be sensitive in grades and not just in a binary way, which would have been perfectly fine, he said, I said, well, look, you know, classical, what Pizzardi has shown, classical logic is out of date. It's all wrong. We have a new fuzzy logic and we need new fuzzy machines to correspond to the new fuzzy logic. And I'm going to build a fuzzy controller for cement kilns that will do this. Right? And the National Science, whatever it was, the Research Council, turned him down. And he was complaining bitterly. And I said to him, hey, what did they say? What did they say when they turned you down? And he said, oh, it was some goddamned philosophy graduate from Oxford who said, dear Professor Mandami, Bertrand Russell showed that classical logic is right, and therefore we're not giving you any money. Well, okay, you know, okay. Look, I have some things to say about approximate truth, more things to say about partial truth, where I think we have an ambiguity. It can mean either part of the truth, which is one thing, or part of it's true, which is another again. And I believe that one of the places where Emil Post's three-valued matrices, which are actually quite non-standard matrices, are potentially very useful, is in understanding partial truth in that second sense. So I'm sort of gradually creeping up on some of these things. I don't have a full theory of approximate truth yet, but maybe one day. No, the microphone is not for that purpose.
Recording. Yes, fair enough. I'm wondering on the terms that you said, if it's still legitimate for one to speak of human flourishing, and I have a couple of concerns that seem to tug away at this term. On the one hand, there was a gesture at parsimony when talking about correspondence theories of truth, which had to posit a fairly queer ontology. There was also some other concerns, namely in the preamble with demoting talk of truth to truths, which obviously lowers the bar to a certain extent. When we speak of human flourishing, it does seem to act as an attractor in the dialectic here. Even if we repudiate the idea of a Hercules or an end of inquiry, it does seem to be a desideratum on case-by-case analyses of how one should adjudicate a certain matter, that one should try to promote human flourishing. The worry I have is that does seem to smuggle in a certain holism about humankind. Human flourishing, humans flourish. Humanity as a whole doesn't flourish. If one's going to maintain that, one smuggles in a certain holism that seems to be spoken against by some of these other considerations. And so I was wondering if you had some words to say about that.
Okay. This is not a fully developed moral theory. Certainly mine is not. Even in Dewey, it's not. Though Dewey's is more developed than my own. And it's clear to me that the theory will not get off the ground without an initial assumption about it being something about human flourishing that matters. That assumption is not self-evident at all. Right? A religious person would, for example, say, that's completely wrong-headed. It isn't about us. You're looking at it wrong. Right? It's not, morality is not about us. It's about him. Yeah? And I myself have a moment of, not so sure. Where does this leave the question, for example, of cruelty to animals? Right? I mean, against which I have strong moral revulsion. Right? I'm some way towards persuading myself that, you know, in the fact that one of the indicators of the possibility that someone will become a serial killer, for example, is a habit when small of setting fire to cats' tails and similar nasty things. You know, maybe it can be done in some sort of quasi-Kantian way, but that's a problem. Right? Now, The question about holism, that's really good. It's meaty. There's a lot of things to be said there, some of which I can say, some of which I'm not clear about yet. To say that human flourishing is a desideratum doesn't mean, not in my mouth anyway, that there is some unique way of flourishing for all humans, which is what we're after. That's not my view. My view is that human beings are extraordinarily various, and that what enables one of them to flourish and what enables another to flourish may be radically different. If I could be anecdotal for a moment, I'm now remembering a television program in which I saw, I think, the happiest guy I've ever seen. Why was he so happy? He just looked like a perfectly contented fellow. And he told his story. When he was very small, he was taken to the zoo. And at the zoo, he met the elephants. And he thought elephants were just the coolest animal ever. And as an adult, he became an elephant keeper in the zoo. And he talked to his bosses and said, look, you don't really understand about elephants. You know, they are creatures of the veldt. What they like is walking. They like to walk together. And it's really very cruel to elephants to keep them penned up. I would like to take our elephants for a walk across the downs. And his boss said, okay, you can arrange it, you do it. And he was shown, with a whole line of elephants, with the little ones holding on to the tails of the mothers, happy as elephants can be, and him as happy as a human being could be, leading them. Right? Now, if that was my life, I'd go crazy. Right? This would not suit me at all. But for him, it's the perfect life. So I think what making human flourishing possible means is, in part, acknowledging that people are different and that we need to make room for their different projects and concerns and values. That's part of what's involved. So this is not a one-shot picture. It's a pluralistic picture, but human flourishing is the general conception under which these pluralistic things all fall. Because it's not a one-shot thing, it's not so readily applicable in a particular case as you might think. Right? If it were, it would be easier, right? But it's not. Right? So it can't be a decision procedure in the way that it might have been had I a different conception of it. And now I guess might be the time to say, one of the things that makes me somewhat uncomfortable about a lot of philosophizing today is when I think about us, I mean people, human beings, I think two things. One is how much we all have in common. Right? Now I'm remembering the Anthropological Museum in Mexico City, which is one of the most spectacular anthropological museums I've ever had the pleasure of being in, which has these wonderful displays of all the different tribes, different kinds, different cultures that Mexico has had over the years, with what their houses were like, what their cooking and eating vessels were like, what their musical instruments were like, what their clothes were like. And one of the things you notice is they're all different and yet they all have certain things in common. Right? They all have to have some kind of music. They all have to have some kind of decoration, and so on. And the other thing that strikes me about human beings is how different each of us is. And an awful lot of philosophy today seems to me to focus on groups of people. women as opposed to men, or people of this race as opposed to people of that race. And that focus seems to me to ignore the more important things, which are what we have in common and what makes each of us different.
Professor Myers.
The microphone, Jane. Yes.
You almost came close to answering my question just there already, but I'll go ahead and ask it anyway. And I think in the paper you probably answered it too, but it's sort of one way to ask it would be to go back to Dworkin's hard cases. I'm not a legal philosopher, I do moral philosophy, but for what it's worth, I'm inclined to agree with you that in those hard cases, we should just say judges are making law and not finding it. And I'm just wondering whether you'd be prepared to say something similar about morality, that it's rife with hard cases where we find ourselves in a sort of way making moral truth, not always discovering it. So, for example, when you were talking about whether there's a morally ideal legal system, I think you sort of quite plausibly stepped back from that and said no, right? And so I'm wondering if you sort of see morality sort of like, not in every case, but in some hard cases like that, where there just isn't, because of all the competing interests and the differences in where people find flourishing and so forth, there's just not going to be a...
Okay. I say again, I don't have a fully developed moral theory. I do have a train of thought, which I think of as the Hamlet theory. Okay. Why the Hamlet theory? Because when I was at the University of Warwick, we were within striking distance of the Royal Shakespeare Theatre. It was 40 minutes drive, and we could go whenever we wanted to, very conveniently. And when Michael Pennington played Hamlet, we went 4 times. It was so good. And every time, on the way home, my Jewish husband and I had the same discussion. Every time. He would say, I don't get it. Where did this idea come from? That marrying your deceased husband's brother is incest. As I understand it, he would go on, in rabbinical law, if a married man dies and there's an available brother, then it's a moral obligation that he should marry the widow and take care of her and the children. And I'm saying, well, where does it come from? I don't know. But every Sunday when I went to Anglican church, they would read the list of people you may not marry. Heaven knows why, but and on that list, I remember, was your deceased husband's brother. I would also say, and for God's sake, don't die, because I would hate to be married to your brother, but that's another matter. Right? Well, when we sat down at home and thought about this and sort of kicked it around, I began to develop a line of thought, which was, look, it's perfectly clear that there's a reasonable rationale for both rules. Right? The rationale for the traditional Jewish rule is you don't want widows and orphans not taken care of if there's a way of doing it. Fine. The rationale for the Anglican rule is you don't want lecherous brother-in-laws eyeing their brothers' wives and perhaps bumping off their brother in order to get them, right? I mean, it all makes perfect sense, but different rules. And this prompted the thought, which may or may not pan out if I ever have occasion and time to develop it, that there might be something like a list of fundamental values to be achieved by a set of moral rules, and quite different ways of satisfying them, which work equally well, or more or less equally well, and no, in principle, reason for choosing between them, right? So that there would be, as it were, a layer that's not relative, but another layer of moral reasoning that is. Okay. Now, as I say, I don't know whether that would pan out if I tried to figure out the details, nor how it would interact with the Deweyan, Jamesian conception I've been appealing to here. But it does seem to me to have some merit. And as you say, as you rightly say, it's structurally similar to what I said about how difficult it seems to me to compare, with respect to what's morally better or worse, complex legal systems embodied in complex modern societies with complex other institutions interacting with them.
Yes.
I just want to observe that this is a foundational problem in Anglicanism because Henry VIII had married his brother Arthur's widow, Catherine of Aragon.
Yes, that's right, yes. And they couldn't get it annulled. Yes. Yes.
Any further question? Professor Democrat.
I just want to pick up on the ethics question that was going around in your comment about animals. And I think there's a sort of foundational theory that gives you probably what you want. It's where I think I'm driven to as well. If you think, well, why does human flourishing matter? It's because of the kinds of creatures that we are, because we're welfare subjects. It's because we're the kinds of things for whom situations can be better and worse, and that things can be good for us and bad for us. And animals are equally welfare subjects. Life can go well or poorly for them. They can flourish or not. And so the very foundation that makes human flourishing the right standard for your political theory allows us to include animals pretty straightforwardly. And then that gives you an answer to Bob's question, the last question, about about where relativism, or your answer to Bob's question, where relativism comes in. It's the foundational thought in the theory is that it's welfare that matters, welfare subjects doing well, flourishing, given the kinds of creatures that they are, the diversity and the similarities in the case of human beings, both having to be taken into account. And because so much of how we flourish or what will be good for us is determined by circumstances and other things that vary from time to time and place to place, et cetera, of course we get the diversity at the surface level of equally good or more or less equally good ways of going about arranging social institutions that so as to allow that kind of flourishing. So it seems to me you don't have the problem that you think you do in terms of animals.
Okay. I don't like the expression welfare subjects, but that's just a verbal matter, right? It suggests something all wrong to me, but that's, I mean, you understand. And what you said actually prompts another thought. In some sense, I have a cat. I don't mean in some sense she's a cat. I mean in some sense I have her. When she was a kitten, her mother brought her to our yard. And then at some point, I think the local animal control people got hold of her. They catch feral cats and spay them. And she's clearly still afraid of human beings. And we've gradually tamed her sufficiently that she will come to be fed, but she doesn't want to be touched. Right? And she now seems to me one of the most contented cats I've ever known, because she has her freedom, but she also has a reliable source of food. And yes, animals, things can go well or poorly for animals too. And in some sense, I think I want to say there's something wrong with a human being who feels nothing when things are going really bad for an animal, especially an animal they could help. Maybe I'm revealing I'm just a middle-aged English woman and in another life I would be rescuing cats in Rome, but I don't think so. I think there's something deep about our relation to animals that I haven't yet articulated. And it does have to do with things can go well or poorly for them too. Yes.
Any further questions? If not, I would ask you to join me in thanking Professor Howe for a very thoughtful work and presentation. Thank you very much.